Welcome to the second webinar of the Intellectual Property Practitioners Consortium. The topic today is technology transfer and commercialization process in developing countries. It started by the team of members who met at Advanced International Certificates course that took place in Seoul last year. And the team members are Moulay Youssef El Hafidi from Morocco, Ojezweni Bondalapati from India, myself from Brazil, Menatala El Serafi from Egypt, Merab Kutsia from Georgia, Dikabo Mogopodi from Botswana. And our mission is to share expertise and best practice, enhance IP awareness, and promote innovation. Our vision is to be a digital platform of intellectual property and business model. And our goal is to bridge the gap between knowledge and intellectual property management. The objective of this webinar is to understand the value of technology transfer and how such initiative can boost innovation. Also, the necessity to have public-private partnership to improve the economy of the developing nation. And to understand how actors or institutions can provide assistance in technology transfer. To have a glance of the topic, I bring here a diagram that shows the interaction among different actors related to technology transfer. Technology transfer as a process of transferring or disseminating technology from A to B. But this will depend on knowledge and technology base, and also the degree of proximity between these different actors. To put some discussion issue in this webinar that will be covered by the different speakers, we'll talk about what sector are using more technology transfer agreement, if the technology transfer office are prepared to encourage technology transfer and innovation, the role of patent in university or TTO is an asset or a burden, and if the actors really innovating or promoting technology transfer, or are they innovation washing? I bring this concept from the greenwashing that was related when a company appeared to be more environmentally friendly than it really is, or is a marketing, or is a matter of time, because in developing countries, we start 10 or 15 years ago with the innovation ecosystem. So it's not time to have good results and to see this improvement. So our agenda will cover, we will start with hoje, that we will talk about the technology transfer in developing countries. After that, our colleague of IPPC, Mena, she will cover the IPM in academia. And our invitees, Shirley Coutinho, she will bring a broad view of the situation here in Brazil, and Mary Grace Rusiak from Philippines, that she will talk about her experience there. And the final remarks and question and answer. So let's start with Oji. I would like to hand over to you, Oji, so you can share your presentation. She's our colleague of IPPC, but also a registered Indian patent agent.
Thank you, Cecilia. So, hi everyone. Thanks for joining us in this webinar. Hope everyone are doing good. So, I'll just give a brief general introduction about technology transfer and how the developing countries are coping up with this technology transfer. So my main agenda is to talk about types of technology transfer agreements, what are the criteria of the technology transfer offices in developing countries, and how national IP offices are taking their own part in developing, in helping or boosting these technology transfers, and also existing technology policies. So coming to this, as Cecilia explained, technology transfer is nothing that it's simply transfer of technology, and also along with technology, some tangible assets too. So there are different states of in technology transfer. That is the preparation, installation, and utilization stage. So the preparation stage is a very beginning stage that involves the market research or the identifying the problem and getting the solution. That's done in the research one. And then the installation, it comes to the production of that idea, how we are going to protect and finding a proper, if you are able to transform your research work into a commercialized product or process, then okay, if you need some other external people or third parties who can help you in bringing that research work into a product. So how we are going to do this licensing work and everything. And the last stage will be the utilization, like the agreements between you and the after process of the agreements, the royalties which you gain from the licensing, is all depends upon the technology transfer. So the technology transfer involves IP, intellectual property assets, mainly patents. So why patents? Patents is a structured form of your research work which can give you a protection, guaranteed protection, apart from like trade secrets. So in technology transfer, we need to transfer technology in a structured form like a document or some know-how things or some trade secrets, some technical work, and also along with that some tangible assets like machinery, or you're exchanging some expertise personal from one organization to another organization to just complete up that project, whatever you have in mind. So in this IPR also protection, we have again three types: excessive, adequate, and weak. So excessive is anything which is too much is also not good. So due to excessive protection, and if especially in patents, most of the patent holders are not ready to allow the people or grant some access. So it's more in some countries, mostly in it depends upon how what type of license agreements you're doing, exclusive or non-exclusive kind of thing. Next, coming to adequate IPR protection, this is good, where you will find some returns to your investment in research and development. And weak IPR protection, as I was saying, like if you just try to have some NDA agreements to just transfer some knowledge like trade secrets from one person to another, you can't guarantee the exploitation of that particular asset of yours. Like, is it going into good hands or not? So you should always be sure that you're having a proper protection. Whatever assets, intangible assets like your research or your invention, everything is protected according to your own regional national laws. And coming to the type of technology transfer, there are two types of technology transfers: vertical transfer and horizontal transfer. So vertical transfer, it is like from research till the production. So it can take place in one organization or in different organization. So it depends only from starting point, like researching, then developing into it product and commercializing that product. Next comes to the horizontal one. It is already developed technology. It's good. It's already commercialized in one region, but that corporation wants to expand its technology into different sectors or in different countries. So they are going to transfer it from already developed nation to a developing countries. This is the horizontal technology transfer. And coming to different type mechanisms of technology transfer. Well aware, we know it's a licensing agreements, and this non-disclosure agreements. We always it is a basic thing, like when from starting discussion from between the organizations, everything should be confidential. That goes into non-disclosure agreement. Bailment is some kind of you're giving access or loan to your equipment or a machinery for a time being. You're not transferring your ownership for that. Memorandum of understanding is a non-binding agreement. It establishes the ground rules for the interaction between the two organizations and the manner in which it should be performed in future. And licensing agreements, it can be an exclusive or non-exclusive, and again sub-licensing agreements, that's general licensing or mechanism, general technology transfer mechanism which is followed everywhere. And material transfer agreements, it involves all the physical apparatus. And cooperative research and development agreement, it is a mutual agreement where there is an exchange of research work between among the organizations. And user facility agreement, it's also kind of where the partner directs the activity that occurs within the framework of the agreement. And non-federal work for others, it is a contract that enables a non-federal partner to ask the laboratory to perform a defined scope of research work in that particular, it shouldn't go towards the outside the scope of your agreement. And personal exchange agreement, here it only depends upon exchanging the research people from the academic or research institute to the private sector, or the private people can come and work in the academic research institute. So it is one and one. This is a comparative analysis which is mostly done in Indian institutes. Like it is mostly it is followed with collaborative and joint research and consultancy and technical support. This type of technology transfer mechanisms are followed in food and health sector in India. So this is a comparative study which is from Indian food and health sectors. And coming to the role of IP officers, IP national officers are someone who has complete control and who administer the IP national laws, and what are their part in this technology agreement. So in developing countries, we are seeing that they are coming forward, like mostly in drafting IP policies, national IP officers, and they are also taking initiative to start training programs for mostly academic institutes. And we are seeing they are providing some incentives in filing procedures of patents and copyrights or trademarks, especially for startups or individuals, in the form of expedited filing procedures in patents or trademarks, and providing some discount fees in government fees or filing. So, what are these exactly apart from IP officers to have this technology transfer? We have a separate branch of organizations, that is technology transfer office or technology licensing officers. So they act as a channel between these research institutes, let them be academic institutes or public research institutes, and the industry structures. So industry people can also be a startup or a large scale, small scale entity. So what are the functionalities of technology transfer offices? Main thing is industrial partnerships, intellectual property protection, and they also can have a counseling and incubations for startups. They can guide them, like if there is any existing research work which needs to be commercialized, and even the researcher people can can initiate or get together, have a funding from government and have a small startup and commercialize it. So apart from this, the TTO should have their own vision and mission, financial strategy, planning, and policies and procedures. So TTO is not only just an organization or non-profit organization, it should also have its own financial strategy. It should have some income where it can support the members, and it should also have the main thing is policies. So the structure of TTO will have a lot of it's almost a complete diversity, like scientists, lawyers, analysts, licensing experts, business managers, and many more. Like mostly because if companies, technology transfers begins from research, that is from institutes, research, academic people, then it should get transferred to corporate people who can commercialize the product. And for the mutual understanding between these two parties, there should be a legal advisory section. And after this licensing agreements and everything, there should be some management people. Coming to the policies, what are the main components of the technology transfer policies have? It should mainly disclose about the disclosure process, the assignment or responsibility who is seeking the patent protection, dispute resolution among the parties, the royalty income distribution, the management of license and contractual performance, etc. But we should also keep in mind that these policies, whatever they are going to draft in their own region, they should be compatible to their own national laws, especially national IP laws and economy policies. This is the main point I want to just stress, where many of the developing countries are unable to draft a solid IP policy till date, which could boost up this technology transfers, because they are just want to adopt the policies which are already performing very well in the developed countries. But we can't adopt something which is already doing well uh, in other countries, because their national laws might differ with our national laws. So we should check the compatibility between our national laws to avoid any further complications. So what are the challenges? The absorptive capacity of the recipient. Here the recipient is the organization which is trying to take it. You can say the licensee. So you should also check whether that organization is ready to take up, is it is capable enough to take that research into a commercialization. And next, policies. Always the policy should be compatible with our own IP national laws or economy policies. So we can't just have something which is already practiced somewhere else. We should just always keep in mind that it should always be compatible, especially with financial policy. And weak institutes in developing countries, still there is a need for expertise uh, who are experts in certain field and who have a wide range of knowledge, who is ready to learn more, actively participate in everything. And inability to make public investments, the government funds, especially now, some countries are coming forward to fund startups, but it's not existing in many of the developing countries still. And lack of vision, this problem arises from the beginning stage, where the research part, where they're unable to see what is the exact problem, and the research work is just getting diluted in terms of commercialization. Okay, we have to commercialize some product, it should be some product, but they are not able to cope up whether this product is really useful right now. Is it just solving all the existing problem or not? So we can't add up. We have a pen. So this is some kind new of my hobby. Not right. Even though, but it is some new idea. Just let's commercialize. So most of the research work is going into drain industry. And another thing, the proper management among public and private sector here comes like fiscal incentives which are given by the government. They are unable to manage those funds properly, both academic people and private people. Private sectors, especially the startups, they are unable to manage the funds which they gain from the government in a proper structured manner. So what could be the suggestive thing? So we know that technology transfer is required, especially in developing countries, for developing countries, and we need expertise. Um, so expertise can't come, so we should go through the practice. And coming to, it should also have a well structured policy. So technology transfer is really important, but it's not an easy task. So developing countries are still behind. So I think there should be a good proper balance between the academic, private, and also a legal structure, proper legal agreements, which addresses every problem, like especially the dispute resolution. And I think I'll just end my presentation now, and I head over to Cecilia again. Thank you, Cecilia.
Okay. Thank you very much, Oji, for your insights and your content. It was very useful. I would like to remember the audience that they can send us questions by using the chat. And I would like to hand over to you, Mena, an assistant professor of the Watt City and of Science and Technology, and also a member of IPPC. Okay, it's up to you right now, so you can share your.
Okay, so good morning, everyone, or good afternoon, or good evening, according to the time in your zone. And today I would like to talk about intellectual property management in academia. And I'm happy to see some researchers among the participants, young researchers actually. So I will try to simplify a little bit in order to tell you why learning about intellectual property is very important for researchers as well. So, yes. So the researchers are always in a race. They're trying to publish their data very fast to get recognized and scientifically. So their unawareness of their innovation potential can make them just rush into publishing their data and ignore the patenting, just to keep up with the race with the other scientists. And this is a big problem because then they can lose all the rights in their innovation and not be able to let it enter the market later on. And the unawareness also of the researchers of the IP management or IPM and the lack of help from the institute they work in can make the transformation of research into market product a very difficult process. So in this presentation, I will try to emphasize on why should researchers know well about IP and how this can protect their right later on. And then I'll talk about the technology transfer offices in developed countries. I get two examples from the US and how it works in the developing countries. I'm sorry, and why is a difference existing and how this affects the researchers. Okay, so the unawareness again of the researchers of IP or the lack of an established system that guides the researchers through the process of the patenting results in many huge problems actually. And this includes that the researchers do not explicitly state the uniqueness of their innovation in the patent. And they maybe are not able to identify the right countries for patenting. And the patent quality or the quality of the filing itself can be very low, and the claims are very poor, so that the patent at the end is very useless and it does not really protect the innovation. And another problem is always identifying the real inventors, like who are the co-authors on the paper and who are those on the patent. This is a big problem that results in many conflicts. And therefore, the money spent on the patents, which are usually thousands of dollars, they will not protect the prototype or the innovation that the researchers have in any way and might not pay off in any way at the end. And this problem is very pronounced in developing countries also, where the IPM or the IP management is not very well established. And consequently, the patents might not emphasize well on the technical rightness of the innovation, the legal strength, and the economic potential. And these 3 points are very important if you want to have a very good patent that really protects the rights of the researchers. Then they should really state clearly what is the unique competitive advantage in their innovation, and what is the legal strengths, like how are they having advantages over others as well from the legal point of view, and what is the economic potential and how their products can really be of a benefit to the market. And so I'll just state some basic information for all researchers that they should know, that they should be aware of. And among these are that all researchers should know that the patents will protect their innovations in specific territories where their patents were filed and granted. So they should carefully pick the regions they want to have a patent in. And this means that if I have my protection in Egypt, for example, this will not prevent anyone in a different country from producing the same product that I have. And so the researcher has to decide if he wants to have this protection local or international, and if he wants to invest in one market or many. And also some the usual information that I used to hear before getting into IP a little bit more is that any patent is valid for 20 years, and nobody can, start having any prototype out of your patent until this 20-year ends. But then I got to know that no, you need to extend always your patent, and you need to pay the renewal fees in order to keep your protection for the innovation you filed for. And there is also a big problem, which is like, as I mentioned before, that people always want to publish fast. So people should be always advised to patent before they publish, because in some countries there is a grace period which is allowed between filing the patent and publishing. But if this grace period, which is like in the US, I guess is around 12 months, if you published and then 12 months later your patent was not filed, then you will not have any protection for this innovation afterwards, and your findings will become public information and anyone can make use of it. So the rushing into publishing or being unaware of the innovation potential that the researcher have can always result in a problem and prevent him from or her from protecting their innovation later on. And actually, one thing also that any researcher should realize is that different contributors to the research work have rights. The funding agency that gave you the money for the innovation, for the research, sorry, that you're doing. The university that supported you and provided facilities and a workplace. The team members that got involved in the project. And therefore, as I said before, they always have to decide which co-authors on the articles can be named as inventors and which people should stay on the article only. And that's why it's better always to file the patent with the innovators, and then afterwards they can publish and put other co-authors. And this unawareness of this point is really a reason behind so many conflicts in academia. And actually, the patent application also is not just a work that can be done by the researcher himself or some legal people. It requires experts in IP management, in technicalities to evaluate the strengths of the innovation, in experts who can do the market research to actually determine that this product have a unique competitive advantage that other products in the market do not have. And at the end, they should also know the market well and decide if the protection should be local or global. And other information that researchers should know is that if a prototype is already available, like I have already a prototype in the lab and I want to do a startup, I need to know very well the difference between different IP fields, the patents. What can I protect under patents, and what can I protect under copyrights? What can I protect under trademarks and the know-how and the trade secret? So each of the IP fields is something that I should really be aware of before starting to transform my process into to the market more. So, for example, if I would need to select a brand name for my product, I have to be very aware and screen a lot of databases that to make sure that my name is very unique and to register it under trademark. And or the design of my product, the colors, the shape, all this can go under the industrial designs, for example. So I need to be aware that I cannot take a name which already exists in the market. I cannot use a logo that is already used by someone else, and I have to have my own uniqueness. And this is also extremely important because if my product would involve an update or putting something new into an innovation that already exists, then I should have a license from the people who have the initial innovation or the initial prototype, because otherwise I'm violating the rights. So this is also very important that if I would start doing research on a specific point, I have to check whether the people who have the foundation for what I will improve on have still their patents valid, and if I need to license before going to the market. And also the one thing people should always remember as researchers, the applicant usually, if you work in an institute or a university, the applicant is always actually the university or the institute itself, and the inventors are the researchers. So this makes the institute or the university the owner of the IP rights. And if someone wants to have any licensing or any agreements, any royalties would be paid back for the university, they would always go to the owner and not the researcher himself. And okay, so the role of the technology development offices. So they need to, they should exist in every university and make sure that certain aspects are taken into consideration to transform an innovation into a product. And what they do is that they examine the technology and identify its competitive advantage. They identify the right countries for IP. They foster connections between academia and industrial collaborators. So in case there is a certain prototype they have, they can do like licensing for other companies to sell, and they can also work on launching startups. They can help in commercialization of your products. And they also need to know how to advance the technology and to have a plan for the long-term stability of this product on the market and to guide the technology to achieve certain milestones required for its development and for its further success. And also the technology transfer office is usually handling all the confidentiality agreements, I'm sorry, and the material transfer agreements, the IP related documents, any report, any kind of documents. They should be the focal point between the researcher and the market or the industry or any partners. Also, they are responsible for handling any finances, like I said, the royalties or any revenues that the owner would make or this prototype would make. They should go to the university directly and not through the researcher. And they should also, if they have like really extra, if they invest in other stuff, also they should make publicity for the products and announcement for any events and ensure successful marketing. So to file your patent, you have to consider all these aspects, like the competitive advantage, the IP. Do I have a good market? With whom should I work? Should I license from someone who have an existing technology and so on? So this is an example of the
Nana?
no, I'm
Nana?
sorry, huh?
Show me it's more.
Okay, okay, I'll try to.
Please.
I'll try. Okay, I'll try to do it. So this is the ranking of the university the technology transfer offices or commercialization offices in the U.S. And if you look, you will find that University of Utah comes in the first place. This is a ranking according to 2012 and 2015, and it takes into consideration like how many patents were issued, how many licenses were issued, how many licensing income, and how many startups were formed, and in addition to the dollars that were invested in each of these offices. So this is the effectiveness of these offices. So if you find that the top 3 U.S. universities, which are Harvard, MIT, and Stanford now, they are not among the first 3. So you find them later here. Harvard is not even in the first 14 here. So what makes this University of Utah office, for example, stand out? This is all information from their website available publicly. So you can find that they have so many available technologies. You can Google, they are so, or look them up. There's so many. And they have a lot of startups. If you just click on therapeutics only, you find so many startups that have originated from this place. And if you look at the structure of their technology and venture commercialization office, they have expertise in everything: technology and venture commercialization, technology management, finance, entrepreneurship, marketing, communications, everything. IP management, they have expertise in every aspect. And also, if you look at Harvard office, it's not among the first 14, but also still it's quite successful, of course. And it has a very well structured, like experts in life sciences and physical sciences and engineering, PhD holders who have technical expertise, business development experts, technology development, communications, financial, IP management, all aspects are covered. So actually, how is the IP management is done in developing countries? So actually, the academicians are mostly responsible for running most offices, especially, for example, in Egypt. We have like the TICO offices that academicians run. And why, of course, we don't have this very well-established structure? Maybe because the innovation and the prototypes that are produced from our academic institute are not so many that they don't require such investment to make a very well-established office structure. Maybe the money that would be spent on investing such structures would be much more than actually the reward or the revenue that will come back to the institute. And also because of financial limitations, maybe. So, okay, we know this situation, but therefore, of course, there's always initiatives, even in Egyptian governments, to teach the academicians about IP and the ones that are running the offices to get them more aware and so on. But therefore, I just want to say a recommendation at the end about this. But let me first say the conclusion of my slides would be that an established system, we should guide the researcher to know why, when, how, and where a patent should be filed. So first of all, why is the patent or is the technology worth patenting? Actually, when? So before it's too late, patent first and then publish. And how? By helping them with handling all the paperwork. And where? By picking the right countries for production. And my final recommendation would be that we should educate as much as we can the researchers and students to be more prepared, because if they would be responsible at this current stage in developing countries, there's not so much investment in making very well established offices. They have to have the foundation of IP, and they have to have the minimum awareness, and like they should be able to guide others. In addition, we should always have obligatory courses on IP management for undergrads, masters, and PhD students, because without this foundation, they will not be able to contribute well to the market, and we will always have this very big gap between basic research and applied work. And that's it. Thank you so much.
Okay, Nena, thank you very much for your presentation. I would like to remember that this webinar is being recorded and will be available on the website of IPPC. I put the link in the chat. And all of you feel free to send us questions, okay? Well, an honor to me to present Shirley Coutinho. She is a president of Fortec, a National Association of Innovation and Technology Transfer Managers, elected in 2018, and an executive manager of a private university, the Cook Rio Innovation Agency, since 2003. So please, Shirley, you can start your presentation and sharing right now, okay? Thank you a lot.
Let's start telling about Brazil is a big country, as you know, and the population nowadays is around 210 million, and very diverse and holds 6 territorial biomes, more than 1,003 animals, plants, species, and so. And most important, we have 6 different climate zones: biomas, Amazon, Pantanal, Cerrado, Caatinga, Pampas, and Atlantic forest. Normally, Brazil is known by these features, but it's important to show that Brazil has technology, innovation, developed competitiveness in various areas. And my presentation will cover since the beginning of the development of IP in Brazil, start with when the court from Portugal came here, that the first industrial incentives inspired in UK, and then the first constitution got some rights for the inventors, then the industrial law, and it's very interesting. It's a characteristic of Brazil, was one of the first to sign the Paris Convention, but it took 70 years to create INPI, that is our institute to protect industrial property. But the development of IP and the innovation depends on knowledge and technology. And the first step to start this in Brazil started with the creation of these 2 agencies. One that is encouraging and support science and technology research, and the others evaluating the superior level education. This was launched, and then this is something that's very special in Brazil. We have 2 platforms. One, you can see all the research, what they are doing, where they are located, with whom they are working, and this is accessible for everyone. this other is another platform that we start with the projects, and we do all the development of our investigation or development project without paper. Everything is online and it functions very well. And this one is a source of information about research results, papers mostly. In the university, until the 60s, teaching was the only mission. Then it was an expansion with the creation of the national graduation system. But during a period of time, and the third mission of the university, let's say, dealing with innovation, partnership with the industrial and service sectors, was only in the 90s, but we have had in the 80s the hyperinflation, and this was said to be a lost decade. And in December 2004, the innovation law was enacted, and this brought a big impact. Because from the 70s to the 80s, we had a huge investment in science and technology, but without any articulation with the technology and industrial development. In the 90s, we increased the capability in the industry, and the new legal framework really changed the environment for innovation, because previous it was quite forbidden private-public collaboration. And since the innovation law was one of the most important, let's say, turning point that we had. And chronologically, you see, in 2002, we started some kind of encouragement for technology transfer officers to university and research centers. With the innovation law, it was obliged for all the universities to have a TTO. And we started FORTEC, that is the Association for Technology Managers, Technology Transfer Managers, and IT people, and all professionals engaged in those activities in 2006, with 43 affiliates, mostly from the South and Southeast, where was at that time more developed industrial sector. But now afterwards, for the lack of professionals, let's say, capable to lead with this question, FORTEC started a professional master degree, and I'll show you the impact. This technology transfer officer mission was, as we already mentioned, it's not necessary to take care of those issues because it's already known. And this is the situation. The distribution of the TTOs that were associated with FORTEC. Nowadays, the last measurement was 2018, and we are actually counting again, but it's around 400 hours. And the master degree is spread all over the country. And this is very important because, as you've known, before the innovation law, all the TTOs were on the south and southeast. Nowadays, from the north to the south, we can talk about, and we have many activities in IP, protection, IPP, strategic use, and technology transfer or knowledge transfer. But we have already some, but still we have gaps. As you see, we have the graduation, but in engineering, is the master's and PhD is increasing, but where are our doctors? Mostly in universities and in the government. It's the opposite of the developed countries. Here, 70% are in university and government, and 30% in the industry, and in developed countries, the opposite. We have some strengths and pitfalls. We have the law, very well actualized in 2016, the innovation law, but it lacks enforcement. Co-ownership that is provided for our law is difficult to manage. Professional capacity is another, mostly in enterprises as well as in industry and service sector. Very high expectation of royalties revenue, lack of IP cultural, let's say the professor that doesn't count knowledge accumulated as a value in the negotiations. I will show this afterwards. And the infrastructure outside the university don't have labs for new entrepreneurs and so on. And lack of proof of concept and prototype. So there is a huge amount. Brazil is the 13th published paper in the very good science publications, but innovation is very low. One of action the government took was spread all over the country the technology institutes that graduate people, but still it's not enough. The strategic use, it depends on the collaboration of labs, R&D groups, enterprise, investors, entrepreneurs, academic institutions. Last year, we were able to do a summit where we joined all associations, it were 7, that leads with this, all these issues, and it was very interesting. And we are trying to work together, angel investors, the capital, researchers, enterprises, and academics. But in the negotiation, as I said, the enterprise brings money and she comes to the university or institute of research because they know that they have knowledge. But in the negotiation, it's very difficult because the wage of money normally, even for the research, is counted heavier than the knowledge. And we are dealing with this background evaluation as an economic investment that the university or the research center does and has to be counted in the negotiation to share the ownership and right of use of the results. At the university where I work, dealing with this difficult of the traditional licensing model, because after the hyperinflation, entrepreneurs and enterprises in Brazil are very high risk averse. And to deal with this risk aversion, because from the lab to the market, it takes normally 5-7 years of high investment and high risk. To deal with this problem, we are working on this time to market, working as a kind of auction contract, and then the university has the knowledge, the enterprise wants to take it to the market, we sign a contract where we share the risk and the investment during a period of time, and at the end of this time, if the enterprise succeeds in taking the technology to the market, it starts paying royalties. If not, it pays a amount of money for the time it was given the exclusivity to try to analyze and to take the technology to the market. And as you know, we need a lot of communication, collaboration, local and global. But without a good research result, we do not make innovation to happen. And then it's necessary, and it's starting this, and I'll show you some new activity. One of the best practices that is supported by the government but engaged a lot of enterprise is to fund and to support startups. Why? Because the big enterprises to introduce a new process or product in the huge structure is very difficult. So the best experience all over the world we learn with the best players like Israel and other countries. If you start with a startup, taking the technology from the lab, making the prototypation and the evaluation, and bring it to the market, the enterprise, the big ones, start using this result. And if it feels that it is okay to incorporate, they normally buy the startup. But it's okay because the entrepreneur will start a new venture, and that's the way this cycle, the virtual cycle for innovation happens. And recently, the government is, and we are working on a new legal framework to support this new business, to improve business environment, work collaboration between private and public and so on, investment facilitation, because in Brazil, bureaucracy is terrible for the new entrepreneur. There is a huge state action to support this new program to leverage the startup ecosystem in Brazil. The economy minister and science and technology and innovation minister both are engaged in this, and many enterprises and entrepreneurs. And fundraising is another problem, and it was started some years ago, a program named Embrapa. Embrapa is the agriculture very successful enterprise, as you know. But the same concept to increase the innovation in the industrial sector. The funds, 1/3 comes from the government and 1/3 from the industrial sector, and the university with the knowledge is not financial but economic, the contribution. And so it makes the full investment. And there is a special institution named SEBRAE, that's a service for small and very PMEs, and they are supporting the entrepreneur, spreading the culture and the innovation with technology improvement in order to add value to the enterprises, very small or medium, normally family-owned or very small enterprises. And this is reaching the innovative that is the startup program. And so there is a long way from the submission of a project and the regulatory examination, so on, the INPI is engaged in this, and it's necessary to know that the INPI is our for section of industrial technologies started the master degree and the PhD on IP and innovation a long time ago. Thank you very much for your attention.
Thank you very much, Shirley, for your great presentation. I'm very proud to say that I was the first student of the master degree and the first student also the PhD degree of the National Institute of Property, Intellectual Property here in Brazil. So it was very nice. So, yes, great. Now, I'm delighted to have Mary Grace, or Ichi, here with us to talk about the experience in Philippines. Please share your presentation with us and go ahead.
Okay, good evening, everybody. Yes, good evening, good afternoon, good morning, wherever you are, whatever time of day it is there. As for me, it's evening, it's 9:16 in the evening here in Manila. Welcome to the webinar brought to you by the Intellectual Property Practitioners Consortium, IPPC. So I'll be sharing with you my presentation. Let me do that right now. Okay, so in the interest of time, we will be going through this in a jiffy. We will not delve too deep into the concepts. This is basically just an introduction on the Innovation and Technology Support Office, or ITSO as we call them in the Philippines. This is your tech transfer office, as you know it probably in your country. And then we will go into a discussion of technology transfer arrangement. Can everybody see my slide?
Yes.
Yes, yes.
Thank you very much for that acknowledgement. Okay, we'll begin now. So again, good morning, good afternoon, good evening. This is Attorney Mary Grace Ichi Puziap, Director of the Documentation, Information, and Technology Transfer Bureau of the Intellectual Property Office of the Philippines. Okay, for the first part, we'll talk about the IPOPIL's government academic industry linkage model, known as the ITSO and the program ITSO 2.0. And then we will go into tech transfer arrangements and a little bit of the legalities as far as tech transfer arrangements is concerned, based on the IP code of the Philippines. So those who are in the legal field, and also those patent agents who have clients, this might be a very good interest to you. Okay, so Innovation and Technology Support Office, or ITSO. This is the flagship program of the Intellectual Property Office of the Philippines, which was rolled out in December of 2010. This is what we call a social franchise, which the original aim of which is to put up patent libraries within local communities. The role of IPOPIL, or the IP office, is to capacitate the ITSO with trainings in prior art search, patent drafting, patent protection, IP management, and all the way to IP commercialization. So how was the ITSO born in the Philippines? So back in 2010, the International IP Institute, IIPI, conducted a study of all publicly available researches by Philippine research institutions, covering the 10-year time frame between 2000 and 2010. Out of a population of 1,000 research articles, it resulted in a 63% of outcomes that are not patentable, 27% of which are potentially patentable. And this led us to think that there might be something with the 63% that could have been done, so that it could be the efforts, the resources put into the research could have been directed to something that is that will advance more the technological development, patentable inventions or digital models. For the 27%, this is quite sad because they're potentially patentable, but they may not have been captured in the system. So we'd like to be able to capture that as well. And so the Innovation and Technology Support Office, the idea of having an ITSO was born. And We launched this formally, publicly, on the 22nd of March 2012, with around 30 public and private universities and research institutions signing in. Public and private universities and research development institutions were enlisted into the network, mainly to provide patent information services. As time went on, these services of the ITSO was expanded. So growing the ITSO network, again, with our first ITSO MOA signing back in 2010, more signing in Cebu. Cebu is a city down south of the Philippines. In 2011, 23 new members, and in 2012, official public launch. By March of 2013, the ITSO has already contributed to patent cooperation treaty applications, the PCT route. And in June 2013, the ITSOs are already involved in technology commercialization. In September 2015, we have grown our network to 85 members. And in July of 2019, because we are going towards the end of a 10-year period, we have thought it best to look back and review how the ITSO has grown and all the issues that it has encountered. And we've decided to do a re-engineering to make our ITSO network stronger under the program called ITSO 2.0. So what is re-engineering the Innovation and Technology Support Office? What does it entail? Why do we have to do it? Well, if I may just go back to what Oji and Mena has discussed earlier, they've already actually given us a window into the problems that beset tech transfer offices. So Mena has identified some problems encountered by the researchers themselves, and Oji has identified challenges that are internal to the structure of the TTO, the Tech Transfer Offices. So it's the same here in the Philippines. These are some of the common issues and concerns under the ITSO 1.0. There is a lack of support or push from the administration because some of the university presidents we've found that they don't even know that an ITSO, the Innovation Technology Support Office, exists in within their structure. Partly because the ITSO has been relegated as a subordinate office of other programs. So we needed to do something about it so that the top management will know about the ITSO and will push for its promotion and for the services for the community. So retention of trained ITSO staff is also a problem because the ITSO staff are not regular. We have to keep training new people. And so it's like a case of one step forward, two steps back every now and then. So under the ITSO 2.0 program, we thought of addressing all of these issues. The publish or perish mindset was also tackled by Mena earlier. It's the race to publish without thinking about patent protection. So this is also the same here. And we would like to recalibrate the mindset of researchers to think of patents on the get-go and not as an afterthought. So those are the issues, and these are the manner, the suggested program under the ITSO 2.0. We've recalibrated our acceptance policy, whereas it used to be a come one, come all type of membership. Right now, there is a vetting process, a tighter vetting process. The technology potential is the biggest factor, but also we would require now something concrete to address the issues that we've discussed earlier. So a commitment from the topmost executive, in the case of universities, it's from the university president, that they will support the programs of the Innovation Technology Support Office. We've also revised the policy on training so that we can move forward, not always have to train on the basics, and so that we can push them all the way to commercialization. We are doing clustering of the ITSOs based on their performance so that we can address their needs on a case-to-case basis, not just a one-size-fits-all kind of program. We are introducing reward system, and we are also developing our ITSO dashboard for better monitoring and evaluation. Another important development under the ITSO 2.0 program is a termination clause that is basically hinged on the ITSO's performance. because we would really want to put our effort on helping them be strong with their technologies and be strong with their push for technology, jumping from their paper, from their research paper, all the way to the community for that to be utilized and commercialized. So that is the engineering of the ITSO 2 under the ITSO 2.0. The ITSO today in the Philippines is numbering 100 strong as of February 2020. We are now 85 academic institutions, 10 government agencies, and 5 operating institutions. So ITSOs and IPSOs are located nationwide. As you can see, the blue marks are our innovation technology support offices, while the red marks are our IP satellite offices. The headquarters of the Intellectual Property Office of the Philippines is in the city of Taguig, Metro Manila, somewhere here in this circle. And you can see that we've scattered our services through the ITSOs and the IPSOs nationwide. So what is the ITSO for? This has already been discussed by Oji and Mena in a general sense. For the Philippine setting, ITSOs are available, they're there, they're visible throughout the IP cycle, the IP creation to protection to utilization. So in the IP creation stage, they provide skills training and patent search, they render patent search services, IP protection, they render patent drafting and prosecution services so that the IP assets of the universities and research institutions will be protected. And in the utilization phase, they do IP audit, they do evaluation of their IP assets, and they help in the total package, the IP management package. So what does the Intellectual Property Office of the Philippines do in order to make this ITSO function to the best that they can? We have different levels of training, from the foundation course to higher level of training in patent search, all the way to patent drafting. We hope that by first making advocates of this ITSO management for the ITSO management team, and then by training them, some more capacitating them to do all of these services for their community, they will become IP experts. So we are also conducting patent accreditation, patent agent qualifying exams, or what we call PACE. So hopefully when the ITSOs are born, they're coming from diverse background, from business, from the sciences, from technical background, and then they all combine, coalesce into this core group that has expertise on IP foundation, patent search, and all the way to patent drafting. Just to give you an indication of how ITSOs, the Innovation Technology Support Offices of the Philippines, are contributing to the entire patent landscape, local patent landscape, you can see that since our public launch in 2012, all the way to last year, 2019, we have the contribution of ITSO patent filings from 7.22% is now up to 54.15%. That means half of our local filings are actually coming from the universities and the research institutions themselves. The numbers as they are not as big as in other countries, but the percentages of the ITSO filing is quite remarkable. You can see the importance of having a tech transfer office within this hub of scientific research and development. The universities are the hub of scientific research and development. All researches, most researches are done here, and the research and development institutes. So we try to capture them, and by strengthening our ITSO network, we are able to do so. These are the numbers for the utility model filings, and you can see a similar trend of growth from 2012 to 2019. ID filings are not as good as UM and patent, but it's quite similar projection from 2012 to 2019. So there you have it. That's a background on our Innovation Technology Support Office. At this point in time, I'll be discussing the technology transfer arrangement. This will be quite legalistic. We'll try to simplify it. But let me just give you a reminder, a guideline. This is the technology transfer arrangement legal aspect in the Philippines. So So this might not necessarily be the same where you are, but discussing it in general might give you an idea of what technology transfer agreements may contain and what you may want to look into to assist your clients when they go into partnership with entities, especially if you're coming to the Philippines. Okay. So tech transfer arrangement is defined under our IP code as contracts or agreements involving transfer of systematic knowledge for the manufacture of a product, application of a process, or rendering of a service, including management contracts. So the keywords are transfer of systematic knowledge. Where there's transfer of systematic knowledge, a TTA would definitely be involved. So it could be TTAs could capture different kinds of transfers. I will not go into that anymore. That has been discussed earlier by Oji. Then it can be in the form of assignment or the traditional form of licensing. So TTAs cover all forms of intellectual property in the Philippines, including licensing of computer software, except computer software developed for the mass market. So what is the role of IPOPHIL, or the Intellectual Property Office of the Philippines, as regards to technology transfer arrangements, or TTA? Well, we register TTAs, we settle disputes involving technology transfer payments, and we develop and implement strategies to promote and facilitate technology transfer. That is why I discussed the Innovation Technology Support Offices to you in our program to facilitate and promote tech transfer through the Innovation Technology Support Office, because it is within our mandate to do so. So under Republic Act 8293, or the Intellectual Property Code of the Philippines, the objective of having TTAs or voluntary licensing agreements cleared and registered with the Documentation, Information and Technology Transfer Bureau is to encourage the transfer and dissemination of technology, as well as to prevent or control practices and conditions that may in particular cases constitute an abuse of intellectual property rights, having an adverse effect on competition and trade. At this point, I'd like to remind you that this is the situation in the Philippines. So it might not be similar that your IP office might not have this mandate. But in the Philippines, the mandate is lodged with the Documentation, Information and Technology Transfer Bureau. In your jurisdiction, you might want to check if you have a competition commission or whatever agency you have under the your Department of Trade and Industry, or an equivalent department. The mandate might be with them. But if your clients are dealing with entities, partnering with entities in the Philippines on account of IP rights covered under a tech trans agreement, please do remember the Documentation, Information and Technology Transfer Bureau. That is my bureau. You have to, well, actually not have to, because it's lodging it with us for review is actually voluntary and not mandatory. But I will discuss with you later the consequences, just in case you decide not to have it reviewed by us and your TTA is found to be non-compliant with the IP code. So if you want to know about tech transfer or voluntary licensing in the Philippines, what you need to focus on are just these four sections: Section 87, 88, 91, and 92. Section 87 would give you a list of prohibited clauses. When we say prohibited clauses, those are the clauses which you should not be putting into your tech trans arrangements. Otherwise, they will be flagged down by my bureau as being non-compliant with the IP code. And therefore, you will not get a clearance for your tech trans arrangement registration. Section 88 will give you mandatory provisions. If prohibited clauses should not be there, mandatory provisions, there are only 4, but they should be there. They should definitely be there. If they're not there, we will tell you, we will advise you to please put in these mandatory provisions to be compliant with the law. If in case there are portions of Section 87 and 88 which you feel are more or less a make or break kind of clause that you really have to have in your tech trans arrangement, then you might want to look into Section 91, because Section 91 grants the Documentation, Information and Technology Transfer Bureau a certain leeway by in giving exemptions for the application of the prohibition in Section 87 and the mandatory provision Section 8. So Section 92 This is what I was discussing earlier, the effect of non-registration with DITTP. You will find it under section 92. I'll discuss more of that later as we go along. In the interest of time, because I only have up to maximum of 25 minutes to discuss all of this with you, I will not go into full detail as to all of the prohibited clauses, but take note of the titles that will already give you an idea of what they are. We will just focus on highlighting the most critical ones and the things that we usually find in TTAs that are coming to our office. So prohibited clauses, these are provisions which are deemed prima facie to have an adverse effect on competition and trade. That's why they are flagged down. So the first prohibited clause is a tie-in purchase. So what are tie-in purchases? These are those clauses which impose upon the licensee the obligation to acquire from a specific source or source of capital goods, intermediate products, raw materials, and other technologies. So if you have a tie-in purchase, that will be flagged down. My team will advise you on whether to reword or change it or take it out altogether. So this is usually present in franchising agreements. So later when we talk about, I'll give you a few statistics on TTA, and you will see that tie-in purchase is one of those provisions where requests for exemption are usually sought. Price fixing. Price fixing is also prohibited. Restriction on production volume and structure is a prohibited clause. There's also a prohibition on the use of competitive technology in non-exclusive agreement is also a prohibited clause. Under this provision, section 87.4, please note that the keyword is non-exclusive. If your agreement is a non-exclusive agreement, then the prohibition on the use of competitive technology is prohibited. But if it's exclusive agreement, then that provision may be sustained. So there's the keyword. What kind of agreement are you getting into? Full or partial purchase options are also prohibited clauses. Free grant back. Free grant back are those that obligate the licensee to transfer for free to the licensor the inventions or improvements. The keyword here is free. So if there is considerable consideration, valuable consideration, then the clause may be permitted in the agreement. What is prohibited is a free grant back. Payment for unused patents. Export restriction. In the case of export restriction, what you have to remember here is this is an instance where there's an instance where export restriction clause may be permitted. And when does it happen? That is when it is justified for the protection of the legitimate interests of the licensor, such as exports to countries where exclusive licenses to manufacture and or distribute have already been granted. This is a case of where one's rights begin is where the other's rights end, if you understand that saying. So if a license has already been granted in a certain territory, then export to that may be precluded. And being in the TTA, it will not fall as a something that can be prohibited. So prohibited, export restriction is only prohibited. There's no legitimate justification for the restriction clause. Restriction to use the technology after term is a prohibited clause. Payment for expired terms is also prohibited. Non-contestability of patents. And R&D restriction. So for this next section 87.12 and section 87.13, the main reason for putting this as a prohibited clause is because basically we want to promote technology transfer, and an R&D restriction as well as adaptation or innovation restriction will prevent technology transfer, innovation, and development. Section 87.14, hold harmless clauses are also prohibited clauses from TTA, and section 15 is a catch-all phrase where other clauses with equivalent effects are prohibited in your tech transfer agreements. An example of clauses with equivalent effects are anti-competitive clauses, such as a stipulation for unreasonable post-termination non-compete covenants. As it stands now, the maximum for post-termination non-compete covenants is 1 year. Beyond that, it's prohibited. Section 88 discusses mandatory provisions. As I mentioned earlier, these are the ones that must be there. So Section 88, if your clients have, if the other party into your TTA is from the Philippines, then the governing law must be stated in the TTA as that of the Philippines. Section 88.2, there has to be a stipulation for continued access to improvement during the life of the tech trans arrangement. In case of arbitration, these are the arbitration rules that are permitted, and the venue of arbitration shall be the Philippines or any neutral country. Tax liability, you have to remember that all Philippine taxes on all payments relating to tech trans arrangements shall be borne by the licensor. If any tax liability is passed on to the licensee, that will be flagged. Okay? So, let's go now to Section 91, exceptional cases. Again, as I've said, we are the law. The objective of the law is like a balancing act. It is promoting tech transfer. It wants to push for tech transfer, but it also wants to prevent abuse of rights as far as IP rights is concerned. So there are prohibited clauses in the TTA and mandatory clauses that must be in the TTA. Again, as I said earlier, if you feel that these clauses are make or break clauses for you and your client, you might want to look at the possibility of requesting for an exemption from the effect of from the applicability of 87 and 88. But these are the guidelines. It has to be linked on what is stated here in Section 91. So it's only on exceptional or meritorious cases, such as in the cases itemized as from A to F, where substantial benefits will accrue to the economy. What happens if you do not register your tech trans arrangement with the Documentation, Information and Technology Transfer Bureau? Well, if it conforms to the provisions of the law, then you're safe. It is conforming to the law, no need to register with the Bureau. But if it's found to be non-conforming with Section 87, 88, or the provisions on voluntary licensing, then the trouble begins because it will automatically render your tech trans arrangement unenforceable. And that's a very big risk for your clients. So we advise that all technology transfer arrangements where the subject matter is IP and IP rights, please go to the Documentation, Information and Technology Transfer Bureau and have them reviewed by us for conformity. And you seek clearance for your TTA. A certificate of clearance will be issued once your provisions or your TTA provisions are conforming to the law, and that you can use that as proof of your the enforceability of your contract. Okay, so I actually ran out of time. It's 26 minutes my clock already. I'll just give you a few statistics that you might be interested in. These are not really very conclusive of TTAs because, as I've said, TTAs in the Philippines are only registered with DITTB on a voluntary basis. So this is not the entire universe of tech trans arrangements entered into in my country. There may be more. There may be so much more. These are only statistics based on those that have been filed with our office. So as a matter of compliance, 60% are compliant. Those that seek exemption are 33%. Those that seek clearance prior to recordal, please take note of this. If you are, if your clients are getting into a trademark licensing agreement, you will require clearance from the DITTB. The clearance that states that your TTA is actually in conformity with the IP code, and that's the only time that the Bureau of Trademark will allow recordal of your trademark licensing agreement. Okay, the top three industries with most TTA registrations based on our file are automobile and motorcycle parts, electronics, food, and related products. But if your clients are not within these industries, you are very much welcome to come to us for registration of your tech trans arrangements. Most common findings and violations are on tax liability, arbitration, free grant back, hold harmless, and anti-competitive clauses. And those that are granted exemptions are mostly on similar items: value-added tax on royalty payment, anti-competitive clauses, grant back on improvements, arbitration, and tie-in purchase, as I mentioned earlier. So that's it for me. Thank you very much. I would love to discuss this in more detail with you in another seminar, maybe. So do watch out for IP Consortium's next webinars, because I'm quite certain that they will deliver the best for your needs. If you have any questions, please don't hesitate to send us an email at ask@ipofil.gov.ph, or you can send me an email that my email address is flashed on the screen, or you can call our customer service at those numbers. Thank you very much, and I wish you all the best for your patent agent activities. Back to you, Cecilia.
Thank you very much, Mary Grace. It was perfect. Really, it was a very rich day. We have Oji with the overview of the main aspects to succeed on technology transfer office in developing countries. Mena, with the point of view of publish or perish mindset, and the need of awareness on IP, the conflicts between papers and patents and IP rights, the owners, and why, when, how, where. I like it very much, this point. Chile, with showing from theory to practice here in Brazil, how, like Philippines, Brazil is trying to re-engineer also the framework of intellectual property, and I hope that we get more results very soon. But I like very much the numbers. Maybe the numbers are the same in Philippines and Egypt and others, that all the master degrees and PhD degrees are working on academia, and we are not really doing a transfer of knowledge between academia and industry. And finally, Mary Grace, you showed a spectacular experience of IT support office, and also your intellectual property office, and all these clause of prohibitive clause and mandatory clause of PPA was great. So I will open for question, and we have some of them already written here. So
Cecilia, you said something about the PCT.
The PCT?
Yes, you sent me a question.
Yes. Can you
about protecting through PCT?
Yes, exactly. Please, I will read the question. Yes, how can we spread the transfer of technology by PCT, and if they, let me see here.
So the patent procedures under the PCT and the
Yes.
MPO provide advantages for
Yes,
strategic
the patent procedure under the PCT and MPO. Yes, so let's repeat the question. So the people say, do not the patent procedure under PCT and APO provide advantage to strategic patenting where protection is sought in several jurisdictions? So if you feel comfortable, I would like to answer that.
Okay. Let's answer this question by my experience at the university. Because the first thing is to verify before patent filing, where are the possibilities of commercializing? Because if you do not have marketing or perspective to commercialization, there is no need to patent, better to publish the paper. But if you have the envisioned the market, it's necessary to look the market is internal to the country or external. And if from the beginning we think the best marketplace to be commercialized is the US, we protect before or at the same time Brazil with the priority by the conventions and so on. If not, we protect, because if the market is exactly this, we have to protect first of all in the US. If it's not, it's more open for other countries, and it's very expensive to protect in each country. We do the protection in Brazil, and as soon as the market needs our negotiation, we do PCT, because the PCT covers most of the countries that sign the patent collaboration, and we have the time to negotiate with enterprise, because the most expensive is to protect each country. And for this, it's better to have already a partner, because we share the cost of the protection in each country. But if the country is exactly one that we can envision at the beginning, we go straight, for instance, to the US. If not, we do the normal. But PCT is really very important for those technologies that can be commercialized or produced abroad.
Okay, great. Thank you very much. The other question, Mary Grace, maybe you can answer. At which stage of the startup?
Cecilia,
Yes.
I just want to add one more point for this PCT filing.
Okay.
Even though, PCT is more advantageous that it is one system where it provides a gateway to file in various countries. But before that process of filing, we have the selection of which countries we have file, and the individual process of, in each country where you have decided to file starts after 30 months once you file the PCT application. But the selection of the countries is in the hands of the applicant itself. So how the Shirley has pointed out that we should have some market analysis before patenting it, whether this invention is commercializable in such area or not. So we have to check all this before, and this thing is the responsibility of the applicant himself. So PCT is just a gateway which provides us, which lessens the filing fees, which provides the information regarding these other national offices, which links all the national offices together. But the main point where we have to file, selection of the countries, it all depends upon the applicant itself. So that's I just want to add that one point over.
Okay, thank you, Oji. Mary Grace, I would like to mention 2 or 3 questions that you can answer because are related. One of them is the last one. Do you also register tech transfer agreement associated with foreign investment? And also technology transfer agreement contained to be suitable to a public university. So these 2 questions are related. Can you answer us, please?
For the tech transfer arrangements within universities, yes, that is basically what our innovation technology support officers are doing. They, together with their day-to-day activities, assisting the universities for registering their tech trans arrangements if they've already found an industry adapter for their research and technological developments. So yes, we do that. We register those TTAs. They come to us for registration. As to tech trans arrangements associated with foreign investments, in the Philippines, we have to delineate. There is a newer law that has been passed on competition for watching out for anti-competitive clauses, and the Philippine Competition Commission is in charge of making sure that there are no anti-competitive activities. So in terms of foreign investments, if the subject matter is IP and IPR, that is our guiding principle right now. If the subject matter is IP or IPR, then tech trans arrangements are covered by the provision of voluntary licensing under the IP code. Otherwise, they might want to check with the Philippine Competition Commission if there's a need for their TTAs to be scrutinized by them. So I hope that answers the question, Cecilia. You were asking another one about the startup business. May I just proceed with answering it? The question is, at which stage of startup business can IP help and support policies coming into action? Well, it is actually a matter of strategy. What we're saying is, from the get-go, startup businesses must already think IP. It should not be an afterthought. But as far as when do you do your IP protection, IP registration, is also a matter of strategy. Because you have to take note that startup businesses might have more advantage keeping their know-how a secret to begin with. They might want to keep it as a trade secret, which is also a protected IP. Because if it is something that, for example, a patentable invention and a patentable process, they might want to keep secret until they're, because it's startup. We're talking about startups. It might be best at some point, for some reasons, depending on their strategy, to keep it as a trade secret in the beginning. But they have to think IP. That's the main thing. They have to think IP already. So whatever decision they make, whether to file it now or file it later or file it midway or in stages, they know the consequences of when they are doing these filings. Because they have to remember that patent protection, for example, it is granted in exchange for disclosure. So if your strategy is to keep, if it's a better strategy for your startup business to keep these processes, this transfer, this know-how, a secret to begin with, then maybe the strategy is not to file it. Maybe the strategy is to ensure that your trade secrets are protected. But if these are, you're willing to do the full disclosure in exchange for the grant of exclusive patent, then go ahead. You can do it at the very start. So it all boils down to a matter of strategy, depending on the kind of startup business there is. So there's no one, strategy to go with. They have to make an assessment. But in all instances, they have to think IP from the get-go.
Really, thank you very much for your point of view. And now, Mena, can you talk about what kind of action can be satisfactory to have transfer of technology successfully in academia and your experience, please?
Okay, so I think it's by bringing more expertise to the offices already that exist, because the more expertise you have in different fields, the more the process will be more efficient. But as I said in the recommendations, we should have education for undergrads, masters, and PhD students about IP and the different fields and integrated into the curriculum. This is an essential step to make everyone aware, and every researcher has to know his rights from the beginning, and also what is expected from him and what are the rights of other people. So this is also through education. And in the current situation where we cannot offer to have a very well-established system in the offices, we have to educate the people who are responsible. And for example, if you have a university where you have experts in business and experts in finance and experts in technology, then you can at least pick faculty members who are experts in the different fields and make them like consultants for the office instead of hiring people who have this job as a full-time only, if the finances does not allow. I think this is the current situation.
Okay, thank you very much. So you mentioned about the IP rights. So you can mention something, Oji, you can mention something about the patent rights or other kind of IP rights during the technology transfer, only to make a summary.
So during the technology transfer, basically it's a licensing agreement between the intangible and tangible assets both. So now intangible comes from the research work, the idea and everything. So to put this idea into a structured form and having it legally protected, a binding, a binding protection from their own national, through the national laws, we should get a patent. So what are the advantages of having a patent, and is simply that the licensor will hold the ownership with him. Even though he transfers some of the rights to commercialize to licensee, he still holds his ownership. That's the one added advantage. And having a patent, it also helps in building the portfolio for academic institute or startup, anything, because everything nowadays, data, the amount of data we are holding, the amount of intangible assets are holding, this is something cutting edge over the competitors for a applicant or for the patentee. The patentee can be anyone, like a startup or a company or an individual. So holding a patent in some related technology, it itself puts him on above his competitors. So apart from that, we have another one, valuation of your IP as well. This also holds value during this technology transfer agreements. So I guess I can just tell that the apart from patents, not only we can also have some trade secrets. Um Trade secrets like we are, but it is not guaranteed that the protection of the trade secret will hold for over a long period of time, and it does not have any legal protection over the trade secret as of now in our national laws. So that's it. Like patents is one of the added value to the licensor to retain his ownership over that technology. So that's
Okay.
it.
Thank you, Oji. So as a final remarks, I will give the word only for our EVTs. My honor to be here, Shirley and Mary Grace. So let's start with Shirley. Your final remarks about this webinar, please.
First of all, thank you very much for the invitation, and it's a great pleasure to share and to learn about all that is happening in all those countries. And to know those people, Mary, I've already known, but it's a great pleasure to get in touch with so nice persons, and it's wonderful to see that the women are all over dealing with technology transfer, IP, and so on. The majority are women, and that's really good. Thanks a lot, and until next time.
Thank you very much, Shirley and Mary Grace. Please send some words for us.
Worldwide. Thank you, and I'm really, really proud of this group that has come together to form this IP consortium coming from the advanced international certificate course, and then coming together and be visible all over the world, coming from different backgrounds, legal, science, business. This is a very good lot. And thank you to all of those who have participated in today's webinar. And we hope we have given you something to expand your knowledge on IP and IP rights. We wish you well for your IP adventure. Thank you.
Thank you very much. Thank you very much for all the audience. And I remind you that this webinar will be available at our website. Thank you very much. Have a nice day. Have a nice night. Have a nice evening. Bye-bye.
Thank you.